What's wrong with it? This is bad. That's why I carry my own cases. Again, I don't carry 500 feet of it because this isn't bad enough.
I know. I was like, oh.
Ooh, nice.
everybody in. did. Thank you so much.
I will then call the matters of City of Waupaca versus William Christopher Zelenski, case numbers 20 TR 1536 and 20 TR 2142. Mr. Zelenski's here in person, along with Attorney Hogan, although I'm not sure you're representing him on these matters, Mr. Hogan. City Attorney Thomas Hart is present on behalf of the city. So what's the first file is operating in violation of a red traffic light, and the other was a speeding citation. What's happening with regard to those cases?
Your Honor, it's been some time since I've had any contact with Mr. Zelenski, and these matters have been tracking along with the criminal matters. If the not guilty plea is maintained here today, then the city would ask that it could make arrangements with your assistant for a trial date.
Is that your desire, Mr. Zelenski, to have the matter set for trial?
Yes, Your Honor.
Okay. Since I've got the criminal case, I'll just keep these traffic, even though they aren't ours. When's the city of Waupaca Day coming?
For the record, Your Honor, the city would not object to Mr. Zelenski appearing by Zoom.
And we'll just set a date later on a city of Waupaca date for trial. And I anticipate the appearance would be via Zoom.
Thank you, Your Honor.
Thank you, Mr. Hart. Then I'm going to also call the matter of State of Wisconsin versus William C. Zelenski, case number 20 CV 254. That is a forfeiture action seeking to forfeit the vehicle. Mr. Zelenski, and I don't know if I had the note yet, 09 Honda Civic LX 4-door that was utilized to transport the firearm in this matter. Does that need to be set for trial, or is there any objection to the forfeiture? I did note that there was a response filed at one time that the defendant's wife may have an interest in that vehicle.
She has not claimed any interest. It is solely titled in Mr. Zelenski's name. That was his response, but his first part of the answer was that he has not been convicted of the crime. He has now been convicted, and I think that there certainly would not be need for a trial. The court can take judicial notice of the facts in the jury trial and homicide case.
Any response, Mr. Hogan?
I don't represent Mr. Zelenski on that civil forfeiture, but I did provide him with the paperwork that the state filed, I believe yesterday. Attorney Isherwood provided me a
Was something filed?
I propose for
Oh. Well, Mr. Zelenski, any comment? Is there any reason why I shouldn't sign that proposed order?
I still maintain that due to marital property law, my wife would have an interest in that vehicle. At least half of it, the value is hers. And also, I would maintain that the vehicle was not used in the commission of the crime at all. I drove my vehicle every day to everywhere I went, and the firearm that was in the vehicle every day since it was put in there, and so the car wasn't used. I didn't use the headlights to light up the scene. I didn't run anyone over. The car wasn't used at all in the commission of the crime whatsoever, so I think it's not connected to the incident.
Which of course is a different answer than he filed in the answer that he filed, he said he hadn't been convicted of a crime. If Mrs. Zelenski has any interest in the vehicle, that would be taken up in their divorce action as a part of a property division.
The only name on the registration is Mr. Zelenski's?
That's correct. And there's no lien holder.
Then I will grant an order for judgment of forfeiture to the extent Ms. Zelenski may have claim for wasting a property, because she may have a marital interest that will certainly be addressed in the divorce action. So I will grant the requested forfeiture. All right, I then will call the matter of State of Wisconsin versus William C. Zelensky, case number 20, CF 343. He's here in person, represented by Attorney Hogan. Assistant District Attorney Isherwood is here on behalf of the state. The matter is set for sentencing today. Is the state prepared to proceed?
Yes, Your Honor.
Mr. Hogan, are you prepared to proceed?
We are. I would note I did file several letters of support to the court. I believe it was on Wednesday. A sort of memo that I drafted, as well as the letters of support we had received. I did receive 2 additional ones this morning that I did not have an opportunity to e-file. I did allow Attorney Isherwood to review them before court. May I approach?
You may approach.
And I would just ask that a copy, well, they'll be e-filed, I can print them afterward. I saw who they were from, but was not able to read them completely.
So, Mr. Zelensky, are you prepared to proceed to sentencing at this time?
Yes, Your Honor.
Mr. Zelensky, initially there was a request for a pre-sentence investigation. The court was advised that you did not wish to have the pre-sentence investigation conducted, and for health reasons or other reasons, we moved up the sentencing date until today. Is that accurate, that you are waiving your right to have the pre-sentence investigation be completed?
Yes, Your Honor.
Ms. Isherwood, is the state in compliance with victim notification and consultation?
We are, Your Honor.
Does anyone wish to present any evidence of any kind?
No, Your Honor.
No.
Ms. Isherwood, you may make your sentencing recommendation then.
Your Honor, I have victim statements. I'm not presenting evidence, but I do have victim statements. And the first one is Beatrice Powell, maternal grandmother of Ryelee Manente Powell. Ready?
Yeah, please. Good morning, Judge Huber. I'd like to thank you for this time in this case. I'd like to thank the jury for getting this right, an intentional homicide on my grandson. I'd like to thank the DA for their hard work. I am speaking today for all the family. Today we have been taken away my first grandson. I love Ryelee very much. He was the light of my life. We laughed all the time. He will be very missed. He took Ryelee from his son Jackson. He will never be a father that he so wanted to be. Wild Bill took and killed him, taking him away. He chose to shoot my grandson. Christmas will be very hard this year and every year. Rylee's birthday is in December. Please, Your Honor, he will be very missed. This man needs to be in prison behind bars before he kills again. I hope he rots in prison for this case. Your Honor, he chose to load a shotgun. He chose to point the shotgun at my grandson with no care of human life. He needs to be in prison behind bars. Again, I hope he rots. He had enough weapons in his car to fill this courtroom. If he was so afraid of Ryelee, so afraid of an unarmed teenager, I can't wait till he meets the inmates and murderers. I hope he is very afraid of going to prison. I hope they serve him justice. He needs to stay in prison without no parole, where he can harm somebody else. Please, Your Honor, take this case very seriously, and I thank you for your time today. Thank you.
Your Honor, the next statement is from Daisha, spelled D-A-E-S-H-A. She is an aunt to Rylee's son Jackson, and she has asked me to read her statement, as obviously this is a very upsetting day. Her statement reads, "What's the worst that would have happened to you? You were getting your animals back. You killed Ryelee in front of our family home, the home I shared most of my memories with him, the house where Ryelee would stomp down the staircase, and jump off the last 3. I now drive past this house looking at it as a nightmare rather than the good memories. I went from an honor roll student on the dance team to quitting and never woke up for school. I felt like I was living in a dark hole. You shattered my mental health and family. It breaks my heart my nephew won't have a daddy to look up to anymore. I will forever miss my brother, Daisha." The next statement is from George Meading. He asked me to read his statement as well. And it reads, "To whom it may concern. On October 19th, 2021, at about 10:30 at night, I lost someone very close to me, not only as a close friend, but as a son. Having kids of your own is known by many people, including myself, is one thing that I can tell you, that it doesn't take blood, conception, or even a piece of paper granting the state's approval to consider someone family. I considered Ryelee as a son, and I loved him no less than I love my biological children. The loss of a child, in the eyes of a parent, is a pain that is uncomparable to those who understand that pain, and unimaginable to those who don't. In my eyes, life is precious, and there is nothing in this world that is worth taking a life over, because life is precious and irreplaceable. My boys mean the world to me, and to have watched his brother, my Rowan, not know how to handle the loss of his brother, and me as a father not knowing how to take my son's pain away. My life turned dark in a way nobody could possibly understand unless they have experienced it for themselves. As I did not handle the loss of Ryelee in the right manner, I do have true regrets for my actions. Every father wants to raise their son to grow up and be a respectable and hardworking man, as I did with Ryelee and as I do with Rowan. I have always taught my child to fight like a man and not use weapons. If you're going to fight, do it right and use your fists. I have since that night learned that if I had not taught Ryelee to fight as a man, but to just turn the other cheek, he may still be here today. If Bill had learned to fight like a man against someone not even half his size, I believe Ryelee would still be here today. My life has been in horribly dark, constantly plagued by nightmares to the point I do not sleep more than a few hours a night. My loving partner has had to stay up countless nights, rubbing my back, holding me as I cry in my sleep, and experience night terrors of the physical nature, so I am capable of getting even a little bit of sleep for work. The life that Bill took that night was not worth a few reptiles, and what he has done is unforgivable. I believe that Bill should receive the maximum sentence because not only did he take Ryelee from this world before his time, but he must also answer for the child of Rylee's, who I can only hope will remember everything of his father, who was taken before his time. Thank you, George. Tara Dalrymple. She is the grandmother of Rylee's son, Jackson.
Your Honor, on October 20th, 2020, it changed our lives forever. I'll never forget the sound of that gunshot. I struggle with PTSD, nightmares, depression, and multiple anxiety disorders since that night. I miss Ryelee, and I thought of him as a son. My daughter, 15, innocent and sweet, was forever changed by this night. Daisha, my daughter, loved to dance. She was on the dance team for 6 years. She had to quit her passion due to depression and nonstop crying spells. She still struggles with PTSD and nightmares. The horrific scene she saw broke her spirit. This happened outside our home. My home was a safe haven, even for Ryelee, until that night. I ran outside into a murder crime scene, and there's Bill with a gun, and a boy shot and killed, and a mother who didn't care her son was dead. I had to uproot my family and move from Van Street because we could still see Ryelee kneeling before the driveway. Psychiatrists, therapy, medications, and we still struggle. Rylee's life meant something. He was just a boy, barely a man. He didn't deserve to die at the hands of Bill. Ryelee was not scary, and he had the biggest heart. Every day that my grandson Jackson lives without his father should be another day Bill lives without his freedom. I ask that you sentence William Zelenski to life in prison without parole. Thank you.
Mackenzie. Mackenzie is going to speak next. And this is Jackson's mother.
Good morning, Your Honor. Yeah. Well, I live with the regret that I even told Bill that I found out that Ryelee and Ashton wanted to steal from him because I just wanted to make sure my son was safe and Ryelee was safe because I loved him. I never knew Bill had it in his own heart to kill Ryelee. Ryelee really... Ryelee told me he was getting so close to Bill, and that Bill actually started to mean something to him. Bill did do things for Ryelee. That's why I just can't put my head around how he could do this to him. My son every day tells me how much he misses his dad. And I asked him if he ever would want to say something to Bill, to ever justify what he ever thinks what happened to his dad, and he told me that he wishes his daddy and the bad man, that's what he calls Bill, would switch places. Bill knew how important a father's love was. He knew how much Ryelee and Jack loved each other. He even handed down the handmade blocks Bill's own father made him when he was a child to Ryelee to give to Jack. Bill's father also passed away. My own father passed away. And only children who have gone through that type of pain understand the empty, lonely feeling growing up without a father, watching the kids at school and in public, getting to spend time with their dads, getting the love that children are supposed to from their dads. It just feels unfair, and a piece will always be missing. And I even grew up looking for that missing piece in unhealthy ways that only made it 10 times worse. Ryelee was my first love and my best friend, and my baby's father. Our baby was so small. This was a very hard time mentally for me and Ryelee. We were only kids. This was when we met Bill a little while after. Tiffany brought him over, and the first interaction was about drugs. Was asking us if we knew anyone to sell any of these drugs or any of the kids around town, how to get them around Waupaca, because he was new to us, new to the kids around town. And Ryelee knew, Bill knew Ryelee had a problem, and he just made it worse with the drugs. He knew Ryelee had a drug problem, and he just made it worse, and he knew that. I just have to say, Ryelee might have stole from Bill, but what Bill has stolen from our son is unforgivable and worth so much more. And I just hope you choose to give him life without parole, because I know in my heart what kind of person Bill is. And I just know he doesn't deserve to walk the streets ever again with the intentions he had every day. Thank you.
And Melissa Manente. Melissa Manente is the maternal grandmother of Ryelee, and her daughters are also coming forward just to show pictures. Strong.
Hello, Your Honor. I am Melissa Manente, Ryelee's maternal grandmother. I will keep this as brief as possible. However, in order to make you understand the impact of his loss, I need to at least tell you some of who he was and why I believe in the man he would have become. There's so much I want to say. He was an extraordinary person. But I realize there isn't time enough in the day for me to say all there is, so I will try to keep it as simple as I can. Even as a young child, he was smart beyond his years, unexpectedly witty, loving and mischievous. He filled the room with laughter and sunshine. His smile could light up the night. It was nearly impossible to stay upset when he was around. He had a way of making people he loved feel encouraged and hopeful about the future when they were down, strong and confident when they were weak, and loved and comforted when they felt alone. He could make you feel understood and accepted in whatever place you were. He was generous and funny, and he had the biggest, most forgiving heart a person could have. He was troubled and struggling from a chaotic and dysfunctional upbringing. His mother struggled with mental health and behavioral issues since childhood. His father and father figures struggled with addiction. And he battled with himself constantly between feeling trapped and destined to live the lifestyle his parents emulated, and wanting to change and give his son the kind of father he himself always wanted. Ryelee was so much more than he has been portrayed during this trial. He was part man, part teenager, filled with machismo, fear, excitement, and confusion. He was part gangster fantasist, like so many young adults these days. You can look outside in any given town in the world. You can look outside in Waupaca, Wisconsin, and see at least a dozen young men dressing, talking, and posturing about like they're gangster rap heroes. An innocent fad for some, a dangerous and deadly idea of reality for others. He was part lost, scared little boy, and part father. Very proud, hands-on father, and he wanted to change his life. I believe he would have. I know for a fact he could have. You see, I didn't know the thug life Ryelee. I knew of him, but I had never experienced that part of him for myself. Ryelee was my firstborn grandchild. He was one of the greatest loves of my life, and he was my friend. Around me, he was respectful, kind, introspective, deep thinking, loving, and hilarious. Our conversations were epic, and our bond is deep and everlasting. In the summer of 2019, he moved his little family to Alabama to live with me. He wanted to get away from the situation here and start a new life. Within a week of being there, he had gotten a job building docks. In a few short months, he was able to buy a car, and to my knowledge, he was sober from hard drugs. He was 17 years old. He got up at 6 o'clock in the morning, worked hard all day, came home and played with his son, fed him, put him to bed, visited with his girlfriend, and played video games. He was living a respectable blue-collar life, and he was so proud of his accomplishments. Unfortunately, for various reasons, they chose to come back here. But my point is, I saw him turn his life around. I saw him setting goals for the future and feeling confident in his ability to reach them. His potential was endless. My boy deserved a chance to become a man. These pictures don't begin to show the depth of my family's love for Ryelee or his depth of love for us. They are a pale imitation of his charisma. Ryelee has 2 aunts who have adored him since the day he was born. Their devastation over his loss and the situation leading to it has been a horror to behold. There are no words to describe the impact his loss has had on his 2 brothers. 2 precious little boys who had a big brother who was devoted to them and their happiness. An entire little family blown apart by a trauma they will forever have to navigate. It has been sad and frustrating to try to explain to his sweet cousins, who barely even understand why he is gone. And my heart breaks for the cousins who will never know him. I have watched helplessly as his 2 lifelong best friends grapple with the pain and rage of this unholy situation. Tara and Daisha, each in their own way brutalized by the events of that night. Mackenzie, already grieving the loss of her own father, now having to navigate losing the love of her young life and her toddler son's father. Ryelee became a father at 16 years old. Jackson was a micro-preemie, weighing just under 2 pounds. Ryelee spent nearly every day at the hospital with him, changing him, touching him, watching this tiny being he helped create wiggling in his incubator, fighting for his life. Ryelee held him in skin-to-skin contact as Jackson became stronger, bonding with him in ways most of us can't imagine. Even as a mother, grandmother, and great-grandmother, I still can't find a word to describe the love Ryelee felt for his son. You can see in nearly every picture they are in together, he is looking at him with the purest love I've ever seen. There are pictures and stories for Jackson, and he will always be told how much his daddy loved him. But no words will ever be a satisfactory replacement of what that would actually feel like. This boy has been robbed of a lifetime of memories. Every milestone will be tainted by the absence of the tangible love and pride of his father. Not only the emotional support, but also any type of financial support for Jackson has been lost. Most of the time when a child loses a parent, they receive support in the form of their parents' accrued Social Security. But Ryelee was barely 18 years old when he was taken from us. I don't think he had ever even filed taxes yet. There is nothing for Jackson. There was nothing to leave. Ryelee's personality was so beautiful, and he would have shared the traits of his heart with his son. How do we give him what only Ryelee could? The ripples of Rylee's loss will never end. I can't really speak to the personal impact Rylee's death has had on these people. It has affected each of us in its own devastating way. The impact it has had on me, particularly as the mother of one of the perpetrators and the grandmother of the victim, is nearly indescribable. There is no way to prepare yourself to stand up in front of a room full of shocked and horrified loved ones to give your 18-year-old grandson's eulogy. I had no idea what I was going to say when I stood there in front of them. There were no words that could ease any of our pain. The only thing I could think to do was tell them about one of our last deep conversations, when he questioned me about why he always accepted people for who they were and forgave things most people wouldn't. I just wanted them all to remember who he was. I need to remember too, because as much as I would like to think Ryelee got his loving, accepting, forgiving heart from me, I know now my heart is nothing compared to his. I may have touted unconditional love and forgiveness to everyone who would listen for as long as I can remember. But now I'm being called to practice what I preach. And most days it's a test. I feel like I'm failing. I'm failing in a lot of ways lately. I'm struggling with motivation to work, unable to concentrate, taking so much time off it's a wonder they keep me. I've even lost the momentum for the writing career I was building. I'm angry in a way I had never imagined possible. My rage will not change the outcome. Ryelee is gone. So I guess I subconsciously give my anger inanimate focus by obsessing about the most minute and mundane things. Like this picture of me with all my grandbabies in 2014. But there were more. So here's a picture of me with all of my grandbabies and my great-grandson in 2019. But, Your Honor, there's more. There are more, and now I will never have the complete picture. It sounds almost petty in light of it all, but it will forever taunt me as an image that should, but never will be. I'm still working on how to enjoy my pictures and memories of Ryelee without it turning to desperate, gasping, raging pain. I'm nearly constantly distracted by this unending nightmare. For 2.5 years, I was haunted by the thought of his last minutes. Now, I'm haunted by the reality of them. I'm supposed to be a writer. What words do I have left? I used them all in a scream that never ends and is now echoed back to me in my voice last plea. Put the gun down and fight like a man. Put down the gun and fight like a man. What imagination do I have left? It's eaten all up with reality. I don't even have to close my eyes to see her stance as she pulled up the gun on his command. I can't erase the image of my grandson's kneeling body crumpled on the ground. I see it now. What time do I have left? I'm trapped in the 10 to 15 seconds it took him to die. Do you know how long 15 seconds is? Please bear with me. Seconds. I will forever wonder what his thoughts were during those sadly brief and shockingly long seconds. For me, his loss happens every day. It seems only just that the man who took my grandson's life should pay with the length of his own. He showed my Ryelee no mercy. I ask that you allow justice to return the favor with a life sentence and no possibility of parole. Thank you.
Oh my gosh, you need to be a writer. That was the last statement, Your Honor.
Do you wish to make an argument then at this time?
Yes, Your Honor. I thought I would first make some comments on the letters of support that were provided to the court. And there are obviously a number of family members who have very fond memories of Bill. It's continually talked about that he was an Eagle Scout over 20 years ago. I think about my nieces and nephews and my cousins who I would see maybe 1 or 2 times a year or 1 or 2 times a decade. And I have wonderful memories of them, but I have absolutely no idea what's going on in their day-to-day lives. And I wouldn't dream of opining on them. I don't blame them for writing the letters, but it's obvious that they do not have an inkling of what Bill Zelenski's life was like. There was a letter from Matthew Schmidt. Bill is an upstanding citizen, and as far as I know, Bill has never been in trouble with the law. As I go through my statement, we will see that that certainly was not true. There was letters from individuals who come into the jail to do jail ministry. And he says, when mistreated by fellow inmates, he did not retaliate. He trusted in the power of truth and told his story. William Zelenski is a manipulator. He's had 3 women in his marriage, 3-part marriage, I think that he's had at least 2 women throughout his marriage. He doesn't follow the norms of society. He had such control over women that they did what he said. And that, there's no better example of that than handing a gun to his mistress, Tiffany Powell, and telling her to hold the loaded gun on her son, and she did it. If that's not proof positive of the control this man had over her, nothing would be. Now, he also had that control over his wife because she went along with his schemes of bringing an extra woman into the marriage. And as you'll see as I go on, that had been going on for many, many, many years. One of the letter from Saul Pina talks about he needs to have parole so that he can do good. Well, if he's truly found God and the Bible, he can do good in prison because there are many people there who could use somebody of faith. But that's where he needs to be doing that good. Not ever out on parole. There was a letter from Jim and Ellen Regenbach, who I happen to know from my days in Portage County, and I thought it was one of the few letters that had some truth in it, because he said, Bill has suffered from serious mental illness most of his life, long before diagnosis and treatment were available to him and his family. So there was an acknowledgement, at least by one, I assume family friend, that he's had to fight mental illness for a long, long time. There was a letter from his brother, John Zelenski, which I think was very helpful because it gave a background of Bill Zelenski that was kind of a black hole, at least as far as I knew, and I assume as far as the court knew. But this letter is also obviously skewed because most of the information, other than the medical information, came from Bill. And so while Dr. Zelenski took it as the truth, I think we'll find through the rest of my presentation that it was far from the truth. He said that Bill joined the Waupaca police force, and he said police work did not suit Bill, but he had a tremendous respect for the work police do. I don't think that's true. I think a very honest statement, there were moments when people around him needed breaks from Bill's erratic behavior or demands, and times where Bill suffered a lot. I think that's very true. And that is the only letter that acknowledged some of Bill's characteristics that were so difficult for the people around him to handle. But one thing that is crying to be mentioned in these letters, in all these letters, is his addiction to methamphetamine and his use of methamphetamine. I believe he hid that from his family because these people didn't have day-to-day contact with Bill. They had letter writing and phone calls. But the evidence is that Bill was using methamphetamine. Bill was selling methamphetamine. Bill and Tiffany were using Ryelee to sell methamphetamine for him. Paul Zelenski wrote a letter, and he wants you to grant Bill Zelenski parole because it's necessary for Bill's well-being. Well, right now, I don't think that should even be a consideration what Bill's well-being is. But what I really took offense at is Paul's comment. In a very literal sense, the lack of health care provided by the jail has caused and contributed to a very serious kidney problem. The fact that he is unable to have something as simple as a sodium-restricted diet is causing major health concerns. And I understand that Paul is only talking about what Bill has told him. But Bill did have a sodium-restricted diet, and in talking to jail staff, Bill didn't like it. So Bill chose if he was going to eat it on any given day. Sometimes he was on it, sometimes he was off. And there's a thing called canteen in the jail, and because Bill had a lot of money, he spent literally thousands of dollars on canteen. I just picked a random day, July 20th, 2023, where he spent $75 on canteen, and most items were between $1 and $3. He bought Milky Ways and Kit Kats and chocolate chip cookies and ramen noodles and beef sticks. He also bought Tums, cupcakes, banana bread, cereals, all highly, highly salted items. Multiple packs of dill pickles and salted cashews. Paul Zelenski blames the jail for his medical condition. I was told he had a stash of these snacks. He used these snacks as money in the pod to get things done for him. I also want to talk about the discipline that he had in the jail, as everybody is talking about, what a fine, upstanding person he was, and how he turned the other cheek when people in the jail were upset with him. I have a discipline report from August of 2022, where he was charged in the jail with disorderly conduct and discharging bodily fluids at an inmate. Inmate Robert Logan stated someone spit into his cell and he would like something to clean it up. Upon review of the video, William Zelenski is seen walking in the cell. He is seen and heard spitting into inmate Logan's cell while inmate Logan was in the cell laying on the bunk. As soon as it occurs, inmate Logan gets up and hits the intercom, informing jail staff. He did not fight back. Mr. Zelenski got disciplined for that. Another incident, disorderly conduct and threatening an inmate. This was also in 2022. Jailer was passing out towels. Inmate Zelenski's cup was moved along the table. Mr. Zelenski saw this and said, "Keep your dirty effing hands off my cup." He kept talking to the inmate who had moved his cup, calling him a effing man-child and a little prick. He then gets up, goes to the cell where that inmate is housed, and threatens him. He was given discipline. This is all while he's waiting for a sentence on a homicide case. The most recent incident...
Hey, well, let me interrupt you there if you're getting to a new incident. Because this request was put on a date I was able to clear most things, but there are some things I just couldn't. This will be very brief, off the record in this matter. Hello, do I have attorney... Who do I have? Coffee on? Or Zon Miller? in the matter of State of Wisconsin versus William Zelenski. You may proceed, Ms. Ishwood.
Thank you, Your Honor. The most recent discipline that Mr. Zelenski had in the jail was just on July 17th, 2023, a few days ago. And I am going to show a short video from that incident. I believe staff in my office are going to play it. And you can see Mr. Zelenski in the wheelchair in the middle of the screen. Thank you, Stacy. Your Honor, there's a couple things in that video that are concerning. You couldn't hear it as it's coming through Zoom, but the last line Mr. Zelenski says as he's shaking his fist in the air is, "I can take a punch. I've been in a fight before." He had no problem jumping out of his wheelchair and going after a person that, according to the video, bumped into the wheel of his wheelchair as he was passing. He was obviously in a very threatening stance toward that individual, and that video goes on for up almost 6 minutes of Mr. Zelenski yelling at that individual in his cell. This is after he's been convicted. This is after he put on the show in the courtroom that he couldn't even stand for the jury when they came in, that he needed 2 officers to help him out of the chair. Just another part of the manipulation of Bill Zelenski. One thing that was talked a lot about in the trial was the fact that Mr. Zelenski had been a police officer. He left that employment in 2005. The records from that indicate that on August 23rd, 2004, Officer Zelenski was ordered to remove offensive stickers attached to the inside of his locker. He leaves the door of his locker open, making the notices clearly visible to anyone walking through. They say things such as, "I'm tired of stupid people. For such a small town, there are a lot of idiots here. My other ride is your mom." On March 26, 2004, he was given a reprimand for failure to properly respond to a subpoena to testify in court. Shortly thereafter, he was involved in 3 different internal affairs investigations. These include Officer Zelenski's emotional reaction to being required to serve mandatory overtime, his unprofessional conduct during a traffic stop, and his failure to timely complete necessary paperwork, resulting in a delay processing a criminal complaint. He was also investigated for a shooting incident where he was on his own property with another officer from the sheriff's department, and they were shooting guns. A neighbor came over and complained that the guns were coming onto his property. Officer Zelenski identified himself as a law enforcement officer, engaged in a verbal altercation with the neighbor, and then discharged a firearm during the altercation. That was considered unacceptable conduct. Criminal referral was made to the district attorney's office, but at that time, District Attorney Snyder could not find a special prosecutor, and so it was never prosecuted. He needed a special prosecutor because Mr. Zelenski was still working as a police officer. The conclusions in his employment record: collectively, this record of service reveals an officer of relatively short seniority, yet having suspensions and written reprimands for a variety of acts of misconduct. Moreover, it reveals an employee with a fundamentally insubordinate attitude towards supervision and an unwillingness to accept full responsibility for his own conduct. The conclusion from the incident with the neighbor: Officer Zelenski's actions in this event, even if you accept his version, represent poor judgment by a law enforcement officer. His actions of engaging in verbal altercation with his neighbor, escalating that altercation, identifying himself as a law enforcement officer, and then discharging his firearm are unacceptable. More significantly, Officer Zelenski's untruth and half-truths during the investigation are also unacceptable. Your Honor, this is significant because the control that Mr. Zelenski had over many members in our community, of people who use drugs and deal drugs, was because he portrayed to them that he was a cop and that he had a special relationship with the Waupaca Police Department and he could get away with anything he wanted. So when he made threats against people, they better not report them because he was a cop. And sadly, they believed him. Ryelee believed him. In 2015, William Zelenski was referred for a domestic abuse incident. In that incident, a number of people in the community, both in Waupaca and Plover, were concerned for his wife's safety. Jim Peglow was at the Zelenski house. He could see that April Zelenski was terrified, and she had whispered to him, "I got to get out of here." He distracted Bill while April could pack up a few things and leave. In her statement back in 2015, she indicated that she had tried to leave previously, but Bill would not allow her. She had a cell phone at the time, but as soon as she left the house, Bill had it disconnected. So she had no means of communication. And there was a bulletin put out to surrounding counties looking for April because they needed to do a welfare check. Nobody knew where she was, nobody could find her, and yet multiple people were calling in with concern for her safety. She contacted the district attorney's office. She indicated she was sticking by him, that she was riding out this manic cycle, and that this cycle had been much worse than the last one. But she thought that the cycle would end in the next few months, and if the cycle starts up again, she'd move out until he got through the cycle. She indicated at multiple times she was afraid for her safety, but she had taken a marriage vow and was willing to stick by him. There was a TRO, temporary restraining order, against Mr. Zelenski later in 2015. And a restraining order was granted on October 8th, 2015. In that case, a former employee of Bill Zelenski had gotten the TRO, or gotten the restraining order. In her petition, she said that she had to call the police because Bill Zelenski came to her home after she had quit and was trying to incite an altercation. He refused to leave my home despite multiple requests and my verbal statement that I felt threatened by his presence. The respondent became irate and irrational. I sought shelter in my residence and called the police for assistance. She was told that a disorderly conduct was filed against the respondent, but I could not find any record of that. She said, specifically, William Zelenski cut me off in his vehicle as I was walking to my door and stood in my way. He forcibly demanded to discuss particular elements of my resignation, and I told him I did not wish to, but I would meet him in a public place. He claimed I was hiding in the shadows, and he tried to goad me into arguing. I felt threatened. I asked him to leave. I told him I was scared. I tried to position myself to get into my apartment. He began yelling. He said I effed up his life, his business, and his marriage. He was so emotional, he became unintelligible to me. He said that if I didn't deal with this right now, he would make me deal with it later. I was able to get to the apartment and call the police. She said throughout my employment, the respondent threatened my well-being. He said he would kill me if I quit. He struck me. He threw me. He held me against a wall. He goaded animals into attacking me. He killed animals in front of me to intimidate me. He admitted on an audio recording that an incident where he shot a target inches from me, he was actually planning to shoot me, but changed his mind at the last minute. I have a coworker also willing to say we were both severely sexually harassed, and I believe William Zelenski put controlled substances in my food. That restraining order was granted. Your Honor, you probably remember that many times during the trial, there were objections because there was fear that I was going to get into other acts. That fear on the part of the defense was because there were so many other acts to get into. I had a other acts motion prepared. I was ready to file it during the trial if I thought it was necessary. But I was trying so hard to keep the trial clean and make a spotless appellate record. But I did have a number of individuals under subpoena for rebuttal. And my plan had been, if I thought it necessary, to file the other acts motion and address that and then call rebuttal witnesses. Allison Rowe, Kelly Schmolt, Bridget Wilcox, Heidi Zittel, Mary Pennington, and Madison Mudrow were all under subpoena. They all had made statements which have been provided to the defense. All of them were ready to testify that they bought drugs from Bill Zelenski, that Bill Zelenski was what some described as a loan shark. He would loan $40 and then expect $1,040 in return as interest. He would threaten when he thought he wasn't being paid. He threatened Mary Pennington by saying he would cut her fingers off and he would make her look like her boyfriend, Timothy Boneline, who, Your Honor may recall, is the one who lost all of his fingers due to frostbite. He told Heidi Zittel that he would cut fingers off for people who owed him money. Those statements were why I had asked the question of April Zelenski about a video that Bill Zelenski showed her. She had no idea why he had showed it, but it was a video of someone cutting another person's fingers off. She said it was disgusting and scary. And here he's using that threat. Alexis Dahl was also on that rebuttal witness list, and she was going to testify that she saw Bill chase Ryelee around with a taser at her house while he was holding his 2-year-old son. He was threatening Ryelee and chasing him. Bill used all kinds of methods to try to collect drug debts from these people. Heidi Zittel he used as a slave. He took her to Alexis Dahl's house and said, "She's here to clean your bathrooms because she owes me money." If Heidi Zittel went to the Quick Trip, Bill Zelenski would send April to take the items from her because she owed him money. Story after story after story all consistently described Bill Zelenski as a drug dealer, as a loan shark, and he continually told these people there was nothing they could do about it because he was a police officer and he had an in with the cops. And the stories from these people that he recruited Ryelee Manente Powell to deal drugs for him. Ashton Toady said that they were trying to stop dealing drugs. We never got to hear from Ryelee if that was in fact true. The letters of support for Bill don't know that Bill was cited for disorderly conduct in Stevens Point because he was arguing with a car salesman and threatening that he was going to go to his home and harass him, and the police had to be called. They don't know a thing about Tiffany and the strange, twisted threesome he maintained. They don't know Tiffany was trying to get away from him, trying to sneak out of town because that's the only way she could leave Bill. She was trying to flee to her mother in Alabama, but each time Bill found out and brought her back. They don't know about the abnormal control he had over people, especially the women in his life. So I've presented documentation of Bill's antisocial behavior back to 2004, almost 20 years. So there's no reason to think in the next 20 or 40 years anything will happen to make him safe to be in society. You are being urged by many people to make him eligible for parole, so he will have hope. Ryelee doesn't have any hope. Ryelee doesn't have 20 or 40 years to look forward to. Ryelee is dead because William Zelenski killed him. I have a letter, Your Honor, that I'm going to try to read. I have a copy for the record. After Ryelee was killed and they cleaned out his apartment, they found a letter that Ryelee wrote to himself. Stop acting like shit's a joke. You're going to F everything up. No joke, this is my life, not just me, but my baby boy. And you're going to hurt him more than anyone. Ryelee, I know it's so hard, but my family is worth the world. WTF am I doing? My son needs me. He can't end up like me. I honestly am no better than my dad. So stop. How can I love myself? I don't know. I don't know how to answer that question. Drugs are so evil. If they weren't around, I would be such a better person. I need to find the person I want to be and stop trying to everyone who thinks this is cool. Ryelee, why are you doing this? You're going to make your baby just as hurt as you were growing up. You just need to want it, and I feel I do, but something inside me pushes the real me away. I just need to fight for what I love, my family. I just give up so easily, like I'm looking for a reason to F up. I think I need to give in and let people in. I need to get into reality and get out of this fake-ass world. The fake-ass world I live in all my mind. I know it's lies, drugs, women, and love. Please, Ryelee, be the man you want. I am so ready to fight. I'm so ready to really change. It's time to stop lying to yourself. You can do this. You just need to stop breaking the temptation. Stop letting it in when that shit is only for fun until it's all you know. Stop and be a man. Signed, Ryelee Manente. Bill Zelenski played a huge part in getting Ryelee, or keeping up his addiction to drugs. He does not deserve hope. He does not deserve parole. Thank you, Your Honor.
Mr. Hogan, do you have any one that you wish to call at this time?
Not at this time, Your Honor. I think the letters that we provided to the court are sufficient.
You may proceed.
Thank you, Your Honor. So I want to address a lot of the things that the state referenced in their argument. Something that stuck out to me when Attorney Isherwood was talking about the other acts evidence that she had a motion to potentially file. She referenced, quote, story after story. And that's exactly what all of that evidence was. Stories. People indicating after this shooting happened, when police officers were investigating, ways to see if they could make Bill to look worse than he was. They heard story after story and received absolutely no evidence. Attorney Isherwood mentions that Bill had an addiction to drugs, that Bill got Ryelee into drugs. This court, during the course of trial, saw, I think, 40 exhibits that police officers recovered from Bill's vehicle the night of the incident. None of that suggested in any way an addiction to methamphetamine. There wasn't a single meth pipe. There wasn't any drugs in that vehicle. I find it really hard to believe that Bill was involved in methamphetamine and there's not a single shred of physical evidence that Bill was. When Bill's blood was tested, as the court heard, there were no drugs in his system at the time. During the lab analyst's testimony, and as I'm sure the court is aware, that meth users can have residual methamphetamine in their system and test positive for it. Bill didn't. And the argument that Bill was involved in drugs has absolutely no support in anything that the defense has received in any of the discovery throughout this case. It was a story, and people not even indicating they observed certain things with their own eyes, but this person told me this about Bill. So when the state wants the court to believe that there's all these other acts, I hope the court understands that there's no evidence of any of that. The state mentioned Ashton Toady talking about stopping selling drugs for Bill. But at a previous pretrial conference, when asked about whether Ashton Toady was going to be a witness in this case, Attorney Isherwood herself indicated, no, because I don't believe he's going to tell the truth. That's one of their witnesses to these alleged other acts that Bill committed in his life. The state referenced three incidences in which he received jail discipline. One incident where he spit in another inmate's cell, another incident where he used foul language and allegedly threatened an inmate, and then the inmate that we saw on the video that does something to Bill Bill stands up out of his chair, and the other inmate kicks Bill quite clearly on that video screen. Those are 3 incidences. Bill, as of today, has spent 1,013 days in that jail. In close confinement with anybody, you're going to get into disagreements, you're going to get into arguments, you're going to get into confrontations. In the jail, 3 incidences over the span of almost 3 years. And I would look at them as not major incidences. We don't see Bill on video attacking the other inmate. We see the other inmate, in fact, attacking Bill, kicking him. We didn't hear about any incidences of Bill actually engaging in physical disturbances, getting into fights at the jail, being punished for that. We heard disorderly conduct. We didn't hear battery by prisoner. The state also referenced and called Bill a manipulator, and regarding particularly the women in his life. The testimony that came out throughout trial, and according to the statements that Tiffany and April provided to law enforcement, was they all knew this relationship existed. That Bill and Tiffany had a relationship while Bill was married. Everybody knew about it. They didn't try to keep it secret. And April even admitted that she was okay with it. Not one person who knew Bill didn't know about this relationship. Everybody knew about it. They didn't try to hide it. Everybody introduced themselves when they would meet people as April would say, "I am Bill's wife," and Tiffany would say, "I'm Bill's girlfriend." They weren't manipulated into this relationship. In fact, I believe the testimony from Tiffany was she would go back to Bill. Not as the state tries to portray it today as Bill would bring her back. Physically, Bill would bring her back when Tiffany called and asked for rides to come back to him. The state talks about an incident while Bill was a police officer, with an incident with his neighbor, an argument that occurs, and Bill discharging a firearm. State references that the prosecutor couldn't find a special prosecutor, meaning there was no one they could find that would bring criminal charges. And I don't know if that's because no crime was actually committed. But what we do know is he wasn't criminally charged. The domestic incident that the state talks about in 2015, there was no criminal charges as a result of that. The state references the restraining order, the injunction, reads the statement by the petitioner in that case, and that the restraining order was granted. No criminal charges as a result of any of those incidences were made against Bill. So all we have is the evidence that the court saw during this trial, these statements from other people, story after story after story, without any sort of evidence that those incidences actually took place. So I'm asking the court to place very little weight on those stories and consider them just what they are, stories by people for whatever reason didn't like Bill. Regarding the incident itself, I'm not going to go through and rehash all the evidence. I know that the court took extensive notes throughout the trial and knows the evidence that came in. A few points that I think are worth re-noting that we saw in this case. Most particularly, the state has portrayed Bill as somebody who's a manipulator, uncaring, only wants his way. And if the court recalls, we saw a body camera from Officer Rodens at the jail, and it's Officer Rodens informing Bill that Ryelee has passed away. And we saw Bill's genuine emotional reaction. Head buried into his hands, crying, saying, "I didn't want any of this to happen." That's the true Bill. When he finds out that somebody he cared about did pass away, he's emotional. That's the first time that he is told that Ryelee is no longer alive. And he cries because he did care for Ryelee. We didn't hear any evidence to suggest that he didn't care for Ryelee. We know that Bill did treat Ryelee somewhat as a son to him. Bill testified to an incident when he first met Ryelee was when he bought him shoes, Ryelee and Jackson shoes, because he knew Ryelee had a thing about shoes, and bought them at an outlet mall. And when he first met Ryelee, wanted to come with a gift of shoes because he knew that that was important to Ryelee. He employed Ryelee at his tree service because he did care about him. No one in this case testified or provided any sort of statement that suggested when Bill left his house that night that he was intending to take Ryelee's life. In fact, no one suggested that. April herself testified that when Bill left, all he wanted to do was get his animals back. In fact, the state, during their closing argument, talked about the definition of intent and how intent doesn't need to be brooded upon, thought about for years, months, days, but it can be formed the instant before. So I think even the state understands that Bill wasn't going out there that night with the intent to hunt Ryelee down. The court knows what Bill's version of that incident is, and we respect that the court follows the jury's verdict in this case. But this is Bill's first criminal conviction. He just turned 47, and he is, in those 47 years, no other prior criminal records. He has, I believe, a disorderly conduct citation, but this is his first involvement being charged with a crime and being convicted of a crime. As I indicated before, he's been now in custody at the Waupaca County Jail or Portage County Jail for 1,013 days. In that time, he was instrumental in bringing the jail ministry and Bible study back to the Waupaca County Jail. When he was first arrested on this case and he was housed at the Portage County Jail. There he met the gentleman who ran the jail ministry and Bible study program. That gentleman is here in court today. When Bill was transported back to Waupaca County Jail, he was surprised to learn that the jail ministry and Bible study program no longer existed at the Waupaca County Jail. I'm not sure at what point in time it stopped being a program at the Waupaca County Jail, but Bill reached out to the gentleman at the Portage County Jail and convinced him this is something that the Waupaca County Jail needs. And that gentleman now does run the jail ministry and Bible study program at the Waupaca County Jail because Bill encouraged him to come to Waupaca and begin that program here. A lot of Rylee's family has talked about Jackson losing his father, and that is something that Bill knows about. Bill did lose his father in 2014, and Bill's father and him were like best friends as well. The court saw the pictures that I included in the sentencing memorandum, of Bill and his father with animals because, as Bill told the court, his father is the one that really instilled in him the love and appreciation for animals and for nature. Bill was only involved with animals for such a long time and cared about animals because of his father. So I know when his father passed away in 2014, he took that really difficultly. While he's been at the jail, he lost his mother as well. Because he was incarcerated for this on bond, he was unable to attend his mother's funeral. Although some of his family were able to record the funeral service, it's my understanding that Bill still has not been able to see the recording of that service. And I know he is remorseful for the behavior he engaged in on October 19th, both because of the deep impact that it had on Ryeelee's family, Bill and his family, and the community as a whole, but because of some of the things that he has been unable to do as well. I quoted the state of Wisconsin's motto forward in the sentencing memorandum that I provided. And they say that the common saying is time heals all wounds. I'm not sure if any amount of time will ever heal the wounds of Bill's actions on October 19th of 2020. Today, Ryeelee's family has made it very clear that they believe Bill should be sentenced to life in prison without the possibility of release. But none of us know what time will bring for everybody. 10, 15, 20, 30 years in the future, perhaps Ryeelee's family believes the exact same feelings that they have today. But perhaps they don't. In our criminal justice system, we have set up procedures put in place where if the court were to allow Bill to be eligible for release on extended supervision at any point, there is a process by which Bill can seek that release. Granting eligibility does not grant his release at any time. It grants the eligibility to seek it. If Bill at some point seeks that in the future, there's procedures by which he goes in front of administrative bodies to determine if that would be appropriate. Ryeelee's family has an opportunity to come forward and give their opinion as to whether Bill at any point should be released. As the court, I'm sure, is aware, the Department of Corrections runs a program called the Restorative Justice Program. And that Restorative Justice Program allows victims and perpetrators of offenses to actually meet one another, to speak to one another, and to discuss the crimes that have been perpetrated. When I read up on the Restorative Justice Program, I found out that sometimes victims actually request dialogue with an offender because some victims claim that they're only able to truly move forward after forgiving an offender for his or her actions. If the court forecloses the eligibility for release, it forecloses the possibility today of everybody involved in this tragedy moving forward. As I indicated before, Ryeelee's family in 15, 20, 30, 40 years may still feel that Bill should never be released from prison. But they may not feel that way. What we're asking the court to do is trust in the procedures that have been put in place, if somebody were to be eligible for release, to allow those procedures to be engaged to determine whether at any point Bill is ever released. Again, the court finding Bill to be eligible is not finding Bill will be released at any point, but allows everybody to potentially move forward and allow the victims a voice to be heard in the future and for change to be made. We understand that the court is going to sentence Bill to life in prison. We're asking the court to allow Bill the eligibility for release to extended supervision after 20 years. And depending on what the victims believe in the future, his abilities to do good in prison, maybe one day he will be released. But eligibility, I think, is going to allow for the possibility of moving forward. And denying the eligibility for release today forecloses that even being a possibility in the future. So for those reasons, we are asking that the court allow eligibility for release. And finally, I would acknowledge the state did file a restitution summary. It is my understanding that Bill does stipulate to that amount as well. Thank you.
Mr. Zelenski, is there anything you wish to tell the court before I pronounce sentence?
Yes, Your Honor. I'd like to thank you. I'm just going to get a little closer. Thank you, Your Honor. First of all, I'd like to say I understand and know Tiffany Rose is not here with us today, but I'm hoping my words make it to her as I offer to her and the entire family and anyone who knows Ryelee my deepest sympathies and condolences for his loss. I know he was loved by many, including myself. And I wish none of this would have happened. And I wish he was still here with us, just like everyone that spoke today. I want to apologize for my part in this tragic loss and the actions that I took that led up to this horrible accident where his life was lost. As Mackenzie stated, I did pass along my building blocks my father made. For Jackson. Because I care very much for Ryelee and Jackson. And so I understand the pain and the sorrow that everyone feels. I never intended for anything like this to happen. I certainly never wanted to shoot Ryelee, and I definitely didn't want him to die. I'm very sorry. And I know the ripple effects of this are gonna touch so many lives and people, and I don't disagree with all the wonderful things people had to say about Ryelee. I agree. He reached out to me
and I wanted to help him every way I could. And I know that they mentioned Ryelee, and I know his mother. Both of them had huge hearts and were always eager to forgive. And he would forgive people when no one else would. And I've learned through my Bible study and becoming as close as possible with God that the only way to true happiness is through Jesus' example to forgive and love our neighbors as ourselves. And I'm hoping as this process continues that we can all focus on that. And that I think if Ryelee was still here with us 20 years from now, he would enjoy going through the woods with me, having a walk, enjoying God's creation. And we'd forgive each other for everything. And I sure hope the rest of us can do the same. And I just ask for your mercy, and please grant me the possibility, and everyone the possibility, to move forward so we can put this pain and sadness and sorrow behind us as much as possible. Yeah. Thank you, Your Honor.
Okay, at this time, I need to take up some closed matters, probate matters. So everyone who's listening in on Zoom, I'm going to be putting you all into the waiting room. Everyone who's in the courtroom, I will have to clear you. All cameras will need to be shut off. But all those, your Zoom, you're just going in the waiting room. You'll be brought back in. so why don't you start bringing in the Zoom people?
Oh, okay. I knew they all went to Ephesus. Yeah, but we're back. Okay. Yep.
Matter of State versus William Zelenski. This truly is a tragedy. The young life of Ryelee Manente Powell was extinguished by Mr. Zelenski. Mr. Zelenski would claim that he considered Ryelee virtually as a son. The The statement of Mackenzie today, at least certainly to some degree, demonstrates a closeness that was being developed between Mr. Zelenski and Ryelee. She indicated that Ryelee had told her that he was getting close to Bill. There are reports that Bill played ball with Ryelee, played other games, had him involved in his tree business, and in many ways was, for lack of a better word, sort of becoming an informal stepfather due to the relationship Mr. Zelenski had with Rylee's mother, Tiffany Powell. So the result of October 20th, 2020 has had a lasting and devastating impact on the family of Ryelee, and obviously has had an impact on the life of Mr. Zelenski. And his supporters. The use of the word tragedy is oftentimes overused in our society. However, I don't believe that's the case here. There is no question, given the finding of the jury, that Mr. Zelenski is going to be sentenced to the state of Wisconsin Department of Corrections for life. The only question that is really before this court today is whether he should ever be eligible for release on some type of extended supervision. These are always extremely, extremely difficult cases. The court, though, when making a determination of eligibility for extended supervision, needs to look at the factors, oftentimes referred as Gallian factors, that it uses in every sentencing. And I will try to examine the facts surrounding this case and Mr. Zelenski in light of those guidelines. The first of the three major Gallian factors is the gravity of the offense. And obviously there is no more serious offense than intentionally taking the life of another. And the legislature has established the sentence of life in prison. The other two major Gallian factors that the court looks at are the individual characteristics of the defendant, the need to protect the public. I guess when I look at the facts of this case, well, obviously the gravity is extreme. We have the death of a young father whose life was just starting, who has a son, Jackson, who basically will never know his father. And unfortunately, we tend to know that children who do not have a father figure in their lives have a significant difficulty over time. The impact to the grandmothers was telling by virtue of their statements today. The impact to Mackenzie was telling by her statement today, and particularly what concerns this court is her feeling of some responsibility because she advised Mr. Zelenski that Ryelee was involved in the theft of the animals. The family has been devastated. I can't answer the questions that Mr. Hogan raised about will that be true 20 years from now, 30 years from now, or even 40 years from now. All I know is that they are significantly devastated now. So there's no question about this being an extremely serious offense. Now, when I weigh this homicide against the spectrum of possible homicides that are out there, ones which may be done for financial gain, in furtherance of other criminal behavior, etc., I can't find that this homicide is the most egregious homicide that has ever been committed, but it's had an egregious and devastating effect on the parties here. So then we need to look at the characteristics of Mr. Zelenski. When we look, Ms. Isherwood did try to present evidence of other bad acts, yet Mr. Zelenski has no prior criminal record. He apparently may have an ordinance violation for disorderly conduct. He very probably has some history of undesirable behavior. Ms. Isherwood referenced allegations of behaviors with former employees that would be certainly characterized as undesirable. Yet, this court has heard from a number of supporters of Mr. Zelenski that he has a very positive record. One letter I was given today from Mr. Nynum, that's NYMAN. The court has some knowledge of him through his participation in drug court, and Mr. Nyman indicates that Mr. Zelenski was instrumental in him being successful in the drug court, taking him to NA meetings, etc. That's positive. Mr. Zelenski has apparently a history of being able to help zoos deal with problematic animals and find animals for the zoos. So certainly has had some positive pro-social behaviors. Mr. Zelenski was in law enforcement. Apparently his involvement in law enforcement certainly causes this court some concerns, particularly the allegations with regard to utilization of a firearm in a dispute with a neighbor. That in many ways is indicative of what happened here to some degree. So that certainly causes concern. The background of Mr. Zelenski shows that he has a college degree from the University of Wisconsin-Stevens Point. He's had training, obviously, in law enforcement. Quite frankly, the fact that he has training in law enforcement and became involved in this causes this court more concern. He knows how to deal. His testimony at trial was he knows how to deal with stressful situations. And obviously, confronting an unarmed teenager with a shotgun certainly seems to have been a more extreme response and would be appropriate under the circumstances. You know, you don't bring a gun to a fist fight, I think, is a common phrase you hear from people. In this case, Mr. Zelenski saw Ryelee coming down the street. He went back to the car, and rather than just getting in the car and driving away, he elected to procure a shotgun and go and meet Ryelee. That's not indicative of someone who's had training and ability to diffuse a situation and to respond appropriately under the circumstances. I remember Mr. Zelenski's testimony was the reason he didn't just lock himself in the car or drive away was because Tiffany was outside of the car at the time. I don't think there's any reasonable or rational reason to believe that Tiffany would have been in any danger from her son. To the extent there was any animosity from Ryelee, it was towards Mr. Zelenski at the time. Some other comments Mr. Zelenski made causes this court significant concern. In correspondence through emails with some of his friends and associates, he indicated that this matter was going to be settled in the streets. he was frustrated apparently with the response of the county sheriff's department and city police departments, frustrated that the officers may have been off duty and other officers weren't responding properly. He wanted to take care of the situation himself. He had in his car a plethora of weapons and devices ranging from switchblades to guns to tasers to handcuffs to bats even. He was out to look for a fight, I believe. And that's really concerning to this court. His claim was that his only concern were the animals. Yet after he found out where the animals were, rather than going to the residence where the animals had been located and he had been told to go, he elected to go to the place where he very well may have expected to find Ryelee, and ultimately did find Ryelee. He indicated he wanted to be sure that Madison didn't give Ryelee a ride to the location of the animals and dispose of them. That is a significant stretch in this court's believability of his story. The fact that once he knew where the animals were, he didn't go there dumbfounds this court if that was his only and primary purpose. He didn't call law enforcement to indicate the animals were there when apparently he was simply honoring the request of the property owner who had indicated the police were there earlier, and she indicated she had no knowledge of them, and so he was going to try to protect her. Much of the story doesn't make a lot of sense. So I think his involvement in this case is certainly aggravating. is a need to protect the public, primarily a need for rehabilitative control. Obviously, he will be confined no matter what I decide today for a lengthy period of time. But I think it is appropriate and necessary because behavior in the jail where he got out of the wheelchair to confront an inmate certainly causes this court some concern. He's quick to anger. He suddenly, with all of his alleged serious health problems, was able to get out and go and confront the other inmate. This court's not so naive as to think that inmates don't scrap among themselves while in the jail. As a general rule, those people confined in the jail are not the most socially cultured and acceptable people and able to control their actions and emotions. Other things that are alleged to have been bad acts, as quite frankly, Mr. Hogan points out, are mostly stories. But I'm certainly concerned about his behavior in the law enforcement agency, and that might be partially a function of some of his, at least for years undiagnosed, and at least others seem to have diagnosed and perceived mental illness. The allegations that Mr. Zelenski was addicted to methamphetamine obviously isn't something I heard before today. The lab results that the court heard based on blood sample taken on the night of the arrest, my recollection, it's been a while since I looked at them, but I looked at my notes yesterday, showed caffeine and nicotine metabolites. No amphetamine metabolites, no methamphetamine, no ethanol, although I heard testimony they could have potentially been drinking and it could have been expelled prior to withdrawal of the blood draw. So I don't know. Obviously, if there's any real support to the belief that Mr. Zelenski has a significant drug issue and was a major drug dealer, that would change this court's attitude of him substantially. But I just don't know whether to believe it or not. I didn't write down all of the names because this issue would rattle them through fairly quickly, but not to unfairly characterize the names. I certainly recognize some of them as a rogues gallery that this court sees for lots of reasons and would have credibility absent some compelling proof. In fact, the court certainly recognizes one of the named individuals faced homicide charges herself, although wasn't acquitted. So I don't know what weight, if any, to give to those types of activities. The loan sharking, maybe, I don't know. if that's actually taking place and Mr. Zelenski's threatening to cut off fingers, that would really bother this court. But if I'm really going to make findings based on that, I would have liked to have had a witness here today telling me that's what the circumstances were. So I'm not putting much weight on those stories. So on balance, I'm left with an individual who has had certainly a period of positive involvement in the community, having served as a park warden or ranger, having advised zoos and individuals with animals, and assisted in milking poisonous venom for purposes of treating poisonings. Some stories of questionable, undesirable behavior. So, you know, things are unclearly balanced in this court's mind. Among the things that cause the most concern to this court is, first, that Mr. Zelenski is not a young gentleman. He is 47 years of age today, so he would have been, what, 45 at the time? Or maybe even 43. Whatever, he's 47 today. He was not a young gentleman on the night of this occurrence. He was trained in law enforcement. He knew what the laws were. He knew how to respond to stressful situations. He knew or claimed to know that Ryelee had previously threatened to beat him up, and he locked Ryelee out of the apartment. But that apparently didn't resolve matters. But he knew he could lock Ryelee out of the car. Why didn't he? He made a conscious decision to confront Ryelee with arguably excessive force under a circumstance where Ryelee apparently wanted to have a fist fight. As I said earlier, you don't take a gun to a fist fight. So I feel a great amount of concern over Mr. Zelenski's behaviors on this occasion. But as I indicated, he does appear to demonstrate true remorse. He certainly has no prior record of any kind. He has had a positive pro-social history, at least within the fields of raising exotic animals and supplying them to zoos and providing expertise related therewith. He's apparently had a positive influence on at least some individuals who've gone through the drug court system. So on balance, I don't believe that Mr. Zelenski is an individual who should never have the possibility of extended supervision. The question is, what is the length of time that should exist before he may apply for extended supervision? Now, as you've heard me talk about the fact that he has law enforcement training, the fact that his behavior on this occasion significantly demonstrated a lack of appreciation of all of his training and experience, the fact that he demonstrated almost a greater desire for revenge than for his true stated belief that he wanted to get his animals back. I think to impose the minimum period time for extended supervision would unduly depreciate the seriousness of his behaviors. Now, obviously, this type of issue, as in most sentencing, is not one that is automatically, magically, numerically calculable. But when I look at the facts of this case, as I indicated, I recognize that generally Mr. Zelenski has had a positive contribution to society at large, but he obviously has significant difficulties and deficits. Hopefully those difficulties and deficits can be dealt with in the confined setting of the state prison system. I concluded that if I make him eligible for an application for extended supervision after 35 years, that will be 2058, he will be 82 years of age. At that point in time, I don't believe, even with his deficits, that he would be constituting much of a danger to society. Obviously, that will be subject to a hearing at that time. So, Mr. Zelenski, I am finding you eligible for extended supervision. That will be 35 years from today's date. I'm certainly cognizant of the fact that you have served 1,013 days, as your attorney pointed out, already in confinement, but because I'm establishing an application date for extended supervision, I'm not considering that time except recognizing that it is there and maybe reducing from a higher number to lower 35. I'm not making any finding for custodial credit. You will be provided a form entitled Written Explanation of a Determinate Life Sentence. You should be aware that I have attached to it the actual state statutes so you can review them yourself, but you should be aware of certain things. Your period at which you cannot request extended supervision may be extended, or if you refuse or neglect to perform required or assigned duties. If your time is extended under this bad time provision, you could be required to serve up to the total length of your sentence in prison, which is life. And the penalties which can be imposed by the Department of Corrections are 10 days for a first offense, 20 days for a second offense, 40 days for a third and each subsequent offense. In addition, if you are placed in an adjustment program or controlled segregation status, your term of confinement can be extended by a number of days equal to 50% of the number of days which you spend in adjustment program or controlled segregation status. Finally, if while you are in prison, you file a lawsuit which the court finds to be filed for a malicious purpose or solely to harass the party against which it is filed, or if you testify falsely or otherwise knowingly offer false evidence or provide false information to the court in that lawsuit, the court can order that your term of confinement be extended up to the total length of your sentence. While you are on extended supervision, you will be subject to certain conditions. If you violate any of those conditions, you may be returned to prison to serve not more than the time remaining on your sentence. The time remaining on your sentence is the total length of your sentence plus any time served in custody. You may file a petition for release to extended supervision with this court. This petition cannot be filed earlier than 90 days before your extended supervision eligibility date. If your petition is filed anytime earlier than the 90 days, the court will deny the petition without a hearing. You must serve a copy of your petition on the district attorney's office, and the district attorney will file a written response to your petition within 45 days after receiving the petition. The court will review your petition in any response filed by the district attorney and may grant or deny your petition without hearing. If the court holds a hearing, their hearing will be before the court without a jury. The district attorney prosecuted you will represent the state at this hearing. Before this court can grant or deny your petition, any victims or any other persons may make or submit a statement relevant to your release to extended supervision. The court cannot grant your petition unless you prove by clear and convincing evidence that you are not a danger to the public. If your petition is granted, this court may impose conditions on the terms of the extended supervision. If this court denies your petition, it will set a date on which you may file another petition. If it is filed prior to the date set by the court, it may be denied without hearing. You may appeal an order denying your petition for release to extended supervision. Do you have any questions about that, sir? I will enter an order for payment restitution in the amount of $3,948.57. I will further direct that you be responsible for Mr. Hogan's attorney's fees. Do we need to include anything else in the sentencing?
Your Honor, the defense will be filing a motion for return of seized property. Generally, the personal property that was in Mr. Zelenski's vehicle that's being held at the Waupaca Police Department. I'll probably be able to get that today or early next week. I don't know if the court then wants to have a deadline for the state to respond to that before the court takes action on it.
Your Honor, the appeal period has to pass, and much of the property has been entered into evidence. I'm not sure what they're looking to have returned. I don't think there's much left. But I don't know the list. But we do have to wait till the appeal period comes.
Anything else to discuss at this time?
No.
Mr. Zelenski, you have, as I indicated, been sentenced to state prison system for life. You will be eligible to request extended supervision after serving 35 years. You are a convicted felon, therefore you may not possess a firearm. Possession of a firearm by you would be a felony offense that would expose you to body and imprisonment. You may not exercise the right to vote. You do have a right to seek post-conviction relief either in this court or the Wisconsin State Court of Appeals. To perfect the right, though, you would need to file a notice of intent to seek the relief within 20 days of today's date. Mr. Hogan will continue to represent you for the next 20 days and assist you in the process. We are adjourned.